Welcome to this in-depth exploration of the appointment, retirement, and removal of trustees.
A really core topic in equity and trusts.
Absolutely. And this deep dive, it's specifically designed to help you navigate this crucial area, drawing from materials made available by the University of London for educational purposes.
That's right. Our aim is really to equip you with a solid understanding, especially for your studies and, of course, for exams.
And just a reminder, this discussion is purely for educational purposes. So we'll be looking at, well, why changes in trustees are necessary in the first place.
And the different ways they can be appointed or retire or even be removed.
Whether that's through the trust document itself or, by statute, or sometimes the court has to step in.
And crucially, what happens to the trust property when trustees change? That vesting point is key.
Exactly. By the end of this, you should have a good grasp of the circumstances for changes, why statutory powers are often, well, preferred.
Yeah, the limitations of trust instrument powers.
How Sections 36 and 39 of the Trustee Act 1925 work, and also Section 19 of TOLATA, that's the Trusts of Land and Appointment of Trustees Act 1996.
And the court's role, plus that whole process of vesting property with the new trustees.
Okay, let's unpack this then. First things first. Why would we even need to change trustees? What triggers it?
That's the fundamental question, isn't it? And there are quite a few situations. Think about incapacity first.
Incapacity, like illness.
Exactly. A trustee might become seriously ill, or if it's a trust company, maybe insolvency, or losing its rights to conduct business. That counts too.
Okay, makes sense. What else?
Then there's unfitness. This is more about behavior, dishonesty, perhaps,
Yeah.
or a significant conflict of interest, something that stops them acting impartially for the beneficiaries.
Right, clear breaches of duty territory.
Precisely. And of course, the inevitable death of a human trustee. That's a common reason.
Okay.
Death, also voluntary retirement. A trustee might just decide they want to step down.
Fair.
Or they might be removed, either by someone who holds that power under the trust document or ultimately by the court.
And sometimes it's not about something going wrong, is it? It might be about making the trust, well, function better.
Exactly. You might want to increase the number of trustees. Sometimes more heads are better for decision-making.
Right.
And particularly with land, having at least 2 trustees is usually needed to facilitate overreaching when the land is sold.
Ah, yes, overreaching. That comes from Section 14 of the Trustee Act 1925 and Section 27 of the Law of Property Act 1925, right? Paying the money to 2 trustees.
That's the one. It protects the buyer. So generally, 2 trustees are preferred. Though, a trust corporation that's defined in Section 6818 of the Trustee Act and Section 205 of the LPA can act alone.
Okay, trust corporations are the exception.
Yes. And remember, for land trusts, there's a limit. Section 34 to the Trustee Act, mirrored in the LPA, says you can't have more than 4 trustees holding the legal title to land.
4 trustees max for land. Got it. And you might also want specific skills.
Definitely. Appointing someone with specific financial or property expertise relevant to the trust assets can be really beneficial.
So, lots of reasons for change. How is it actually done? The trust document itself can set out the rules, can it?
It absolutely can. Settlers often reserve that power for themselves. Or they might give it to specific people named in the document, or, quite commonly, to the current trustees, the office holders.
But relying just on the trust instrument, that can have problems, can it? What if the settler becomes incapable or dies?
Exactly, that power might just disappear. Or what if the named individual becomes incapable or dies? Same problem.
Right.
And even if the power is with the trustees, if it's badly drafted or has really specific conditions, well, it might just fail when you need it.
Is there a case on that?
Yes. Wheeler and DeRochelle from 1896 is a good example of how conditional powers can cause real headaches.
Wheeler and DeRochelle, okay.
And that's precisely why the statutory powers are so vital. They provide a fallback, a more reliable framework.
Okay, so let's get into those statutory powers. The Trustee Act 1925 is the big one here, isn't it? Sections 36 and 39 seem crucial for exams.
Absolutely fundamental. And a key point to remember, really drum this in for exams, is that under the 1925 Act, death is the only thing that automatically discharges a trustee.
Just death.
Just death. And because trustees usually hold property as joint tenants, when one dies, their share just vanishes, effectively. It doesn't go into their personal estate.
Right, survivorship. So if the trust document is silent or the power in it can't be used, who appoints the replacement?
Section 36, subsection 1, Shellboy.36 of the Trustee Act gives us the answer. If there's no one able or willing under the trust instrument, then the surviving or continuing trustees have the power to appoint.
The remaining trustees themselves?
Yes, and importantly, if all the trustees have died, the power shifts to the personal representatives, the executors, or administrators of the last trustee to die. They can then appoint new ones.
Okay, that covers vacancies. What about a trustee who just wants out? Voluntary retirement.
Section 36, subsection 8, Shella 368, deals with that. A trustee who wants to retire or refuses to act may appoint their replacement if they're willing to actually participate in the appointment process.
Okay, they can appoint their successor.
But, and this is a really critical point, tested in exams, the appointment is void. It fails if that retiring or refusing trustee is willing to join in the appointment but is just ignored or left out.
Ah, so you can't just bypass them if they're willing.
No. The case recodes to Parsons from 1886 established that.
Yeah.
The law wants their input if they're willing to give it. Remember, recodes to Parsons.
Got it. Recodes to Parsons. Don't exclude a willing retiree. What if a trustee isn't willing to leave but they're, well, not up to the job anymore, or
Sure.
they're just absent?
Right. Section 36(1), back to subsection 1, also covers replacing trustees who become unfit or legally incapable, maybe due to mental incapacity, or remain out of the UK for more than 12 months continuously.
Okay.
In those specific situations, the other trustees can replace them without needing their consent or participation in appointing the new trustee.
Even if the trustee being replaced objects to being removed.
Yes. This is different from the S.36 retirement situation. Even if the unfit or incapable or long absent trustee wants to be involved in their own removal or replacement, the other trustees can proceed without them under its .3611.
Is there a case confirming that distinction?
Yes, Re Stoneham St. from 1953. It confirms that for a replacement under S.361 grounds, the consent of the outgoing trustee isn't needed, unlike the situation in Recodes to Parsons for a willing retiree under S.368. Remember Re Stoneham.
Re Stoneham St. Crucial distinction.
Okay.
And Section 39, that allows retirement without immediate replacement.
Exactly. Section 39 allows a trustee to be discharged without a new one being appointed, provided, and this is the condition, there will still be at least 2 individual trustees left, or a trust corporation remaining, to run the trust.
So you can't leave the trust with just one individual trustee under S.39.
Correct. It ensures continuity of management.
Okay, that covers the Trustee Act 1925 powers pretty well. Let's shift gears to the Trusts of Land and Appointment of Trustees Act, 1996 Tolada. Section 19 seems like a big deal for beneficiaries.
It was, yes. A significant shift. Section 19 Tolada effectively reversed, or at least partially reversed, the old position established in Re Brockbank.
Re Brockbank. That was the case that said beneficiaries couldn't use the Saunders v. Vautier rule to force the appointment of their chosen trustees, right?
Precisely. Saunders v. Vautier allows beneficiaries who are all adult, capable, and together absolutely entitled to end the trust. But Re Brockbank said that didn't extend to telling the existing trustees who to appoint next.
So what does Section 19 allow now?
Section 19 gives those beneficiaries, the ones who are collectively of full age, have capacity, and are absolutely entitled to the trust property, the power to give a written direction to the existing trustees.
A written direction to do what?
To require the trustees to retire and to appoint the specific person or persons nominated by the beneficiaries as the new trustee or trustees.
Wow, that's quite a power shift towards the beneficiaries.
It is. It reflects a move towards giving beneficiaries more, say, more agency.
Are there limits? Can the settlor stop this?
Yes. Definitely. Section 21 of Tolada explicitly says the settlor can put a clause in the trust document to exclude the operation of Section 19. So the settlor's intention can override it.
Okay, so check the trust instrument first. Any other potential issues with Section 19?
There's a bit of a debate around the definition of beneficiary in Section 22 of Tolada. It defines a beneficiary quite broadly as anyone interested in the trust property.
Seems straightforward.
Well, the argument is whether this includes beneficiaries under a discretionary trust. They don't have a fixed interest in the same way, do they? Remember cases like Gartside v. IRC or Stevenson v. Barclays Bank in the Saunders v. Vautier context?
Right. Objects of a discretionary trust only have a hope, not a definite share.
Exactly. So it's argued that because they aren't absolutely entitled collectively, the power under Section 19 might not actually apply to beneficiaries of discretionary trusts. It's an important potential limitation to be aware of for exams.
That's a really important nuance. Okay. Now, all these powers, appointing, removing, retiring trustees, they aren't just administrative tools, are they? There's a duty involved.
Absolutely critical point.
Yeah.
These powers, when exercised by trustees or others given the power in the trust instrument, are fiduciary powers,
Fiduciary meaning.
meaning they must be exercised in the best interests of the beneficiaries as a whole, not for the trustee's own benefit or the benefit of some third party or for any ulterior motive. The beneficiary's welfare is paramount.
Can we look at some examples? Like those study tasks often set. What about appointing someone just because they need the money?
Classic example. Say Fred is a trustee and he appoints his sister Stella, not because she's qualified, but because Fred wants her to get the trustee fees as she's struggling financially. That's invalid. It's for Stella's benefit, not the beneficiary's. Breach of fiduciary duty.
Okay. What about retiring because you just can't stand the beneficiaries anymore?
That's trickier. Say Simon, a trustee, genuinely develops such animosity towards the beneficiaries that he feels he can no longer exercise his duties impartially, especially if it's a discretionary trust.
Uh-huh.
If his retirement is genuinely driven by that inability to act in their best interests anymore, it could potentially be seen as a valid exercise of his power. He's removing himself because he can't fulfill the role properly.
Okay. And using the power to gain some other advantage, like controlling company shares held by the trust.
Another clear breach. Imagine Sam set up a trust holding company shares. He kept the power to appoint trustees. The current trustee, Exco, refuses to vote the shares in a way that benefits Sam's other private business.
Right.
If Sam then removes Exco and appoints Yco specifically to get them to vote the shares his way for his personal gain, that's highly likely to be a breach. He's using the appointment power for his own collateral advantage.
Makes sense. And finally, retiring just because the beneficiaries ask. No other reason.
Generally, no. If Arthur retires solely because the beneficiaries requested it, without any sound administrative reason or benefit to the trust, that's usually not considered a proper exercise of the power on its own.
But what if their request highlights a real problem?
Well, if their request brings to light valid reasons why Arthur's retirement would be in the best interests of the trust, maybe he lacks expertise needed now, or there's unmanageable conflict hindering administration, then it might be acceptable. But the reason must be sound, not just the request itself.
Okay. And that power beneficiaries have under Section 19 of Talata, is that fiduciary?
That's the interesting distinction. It's generally thought that the power under Section 19, exercised by the beneficiaries themselves, is not fiduciary.
Why not?
Because the beneficiaries are acting in their own interests when they exercise it. They aren't expected to balance their interests against others or the abstract good of the trust, in the same way a trustee exercising a power must.
Right, they're acting as owners, essentially. Okay. So what if everything breaks down? No one can or will act. Powers are defective, trustees are warring. What happens then?
That's where the court safety net comes in. Equity's maxim holds true. A trust will not fail for want of a trustee.
But you can't force someone to be a trustee.
No, you can't compel someone. But if there's a gap or a serious problem that can't be fixed using the trust instrument or statutory powers, the court has jurisdiction to step in, both statutory and inherent.
Let's take the statutory power first. Section 41 of the Trustee Act, 1925.
Yes, Section 41. This gives the court the power to appoint new trustees, either additional ones or replacements, whenever it's expedient to do so, and it's inexpedient, difficult, or impracticable to do it without the court's help.
So it's for difficult situations.
Exactly. But it's meant to be a last resort. If there's a valid power in the trust document or under statute that could be used, the court generally won't intervene under Section 41.
Is there case law on that?
Yes. Gibbons Trusts from 1882 emphasizes that court involvement should be avoided if other powers exist. Although, if the validity or scope of an existing power is genuinely uncertain, the court might step in, as seen in Mays Will Trusts from 1941.
Gibbons and Ray Mays. Okay. When the court does appoint under Section 41, what guides its decision? Who does it choose?
It follows established principles, famously set out in Re Tempest back in 1866.
Re Tempest. Key case. What are the principles?
Well, the court considers the settler's wishes, if known. It tries not to appoint someone who would favor one set of beneficiaries over another. And fundamentally, it aims to appoint people who will promote the proper execution of the trust in the beneficiary's best interests.
Okay, settlers' wishes, impartiality, promoting the trust. Makes sense. What about the court's inherent jurisdiction? When does that come into play?
The inherent jurisdiction is the court's fundamental power over trusts. It's often used for removal or replacement, where Section 41 or other powers aren't quite suitable or available.
How broad is this inherent power?
It's pretty broad. The court can intervene if the very continuation or proper execution of the trust is threatened. The leading case here is Letterstedt v. Browers from 1884.
Letterstedt v. Browers. And the main consideration.
Always the welfare of the beneficiaries. That's the paramount concern. But it's important to note, the court is often reluctant to remove a trustee appointed by the settlor. Mere friction or disagreement between trustees, or between trustees and beneficiaries, usually isn't enough on its own. It needs to be something that genuinely endangers the trust property, or its proper administration.
Okay, so a high bar for inherent jurisdiction removal. Now, once we have a new trustee appointed, how do they actually get control of the trust assets, the vesting point you mentioned earlier?
Yes, vesting. This is absolutely crucial. A new trustee isn't fully in until the trust property is legally vested in them. They need legal title to manage the assets.
And retiring trustees need to give it up.
Exactly. Retiring or removed trustees must legally transfer the property to the new and any continuing trustees, so they all hold it together as joint owners. If a removed trustee refuses, that's a breach of trust, and possibly contempt of court if there's an order.
How is this transfer, this vesting, actually done? Is it complicated?
It depends on the asset. Section 40 of the Trustee Act 1925 provides a useful shortcut for some things.
Section 40, how does that help?
The deed used to appoint the new trustee can itself act as the vesting instrument. It can automatically transfer the legal title for certain types of property, specifically property that can be transferred by deed, like chattels, personal items, maybe some debts.
So the appointment deed does the job for those. What about land or shares?
No. Section 40 doesn't cover everything. For land, you still need the proper land registry forms or registered disposition under the Land Registration Act 2002 for registered land. For shares in a company, you need specific stock transfer forms completed and registered with the company. Those require separate steps beyond the appointment deed itself.
Right. Specific transfer rules for land and shares. You mentioned something earlier about managing and custodian trustees in big trusts. How does that affect vesting?
Yes, that's a practical solution, often used for large, complex trusts, maybe pension funds or big charities, where trustee changes might happen more often.
How does it work?
You split the roles. You have a custodian trustee, usually a bank or trust corporation, whose only job is to hold the legal title to all the trust assets. They act on instructions.
And the managing trustees?
They are the ones who actually run the trust, make investment decisions, decide on distributions, and so on. They direct the custodian trustee.
So the benefit is?
When a managing trustee changes, retires, is appointed, whatever you often don't need to go through the whole process of revesting all the underlying assets. The custodian trustee still holds the legal title. You just need a deed to change the managing trustee lineup. It avoids a lot of paperwork and cost, especially with diverse assets.
Clever. A very practical mechanism. Okay, this has been incredibly detailed. Thinking about our listeners studying for exams, what's the best way to approach this topic? Key takeaways.
Right, exam focus. I think the most important thing is to understand the why behind these rules. Why do we have powers of appointment, retirement, removal? It's all about ensuring the trust continues effectively and solely for the beneficiary's benefit.
Understand the purpose.
Yes. Then you absolutely must know the key statutory sections inside out. Sections 36, 39, and 41 of the Trustee Act 1925 and Section 19 of TLATA 1996 know what they allow, the conditions, the limitations,
Know the sections.
and the key cases that interpret them. We've mentioned quite a few: re Wheeler, re Costa Parsons, re Stoneham, re Brockbank, re Tempest, Letterstedt v. Browers. Know the basic facts and, more importantly, the legal principle each case establishes. Be ready to cite them.
Okay, know the cases too.
Definitely.
Mm-hmm.
Then practice applying these rules and case principles to problem questions. Those hypothetical scenarios really test your understanding.
Application is key.
And always remember the fiduciary duty aspect. When it's trustees or others exercising powers under the instrument or statute, that duty underpins everything.
The fiduciary overlay.
And finally, understand the hierarchy. How do powers in the trust instrument, statutory powers, and the court's jurisdiction interact? When does each one apply? Knowing that interplay is crucial for tackling complex questions.
That's excellent practical advice. So, to quickly recap, We've looked at why trustee changes happen, the sources of power, the trust document, statute like the Trustee Act 25 and Tilada 96, and the court.
Highlighting that crucial fiduciary duty throughout.
Yes, and the mechanics of actually getting the property vested in the new trustees. It's been a really thorough exploration, drawing on those excellent University of London materials. And remember, this is all for educational purposes to support your learning.
Indeed. And perhaps a final thought for you to mull over as you study. Considering all these different ways trustees can be changed, what do you think is ultimately the most significant factor in ensuring a trust is secure and benefits the beneficiaries in the long run?
Or maybe another angle. How might the sheer complexity of assets today, digital assets, complex financial instruments, challenge these quite traditional rules about appointing trustees and vesting property?
Good questions. Lots to think about.
Definitely food for thought. We really encourage you to dive deeper into your University of London materials and the recommended texts, Penner's Chapter 8 and Virgo's Chapter 12, specifically sections 12.4 to 12.6, cover this area well. Thank you for joining us on this deep dive.